And you are?
My name is Elisa Gorshinen.
I'm Maya Weber,
And Connor Slutsky.
And who's your team?
and that's Mr. Brown.
Right. Thank you. Thank you for being here. All right, we're going to do question 1. When a choice is made, it is better to allow those who preach racial hate to expend their venom or hatred in rhetoric, speech-making, rather than to be panicked into embarking on the dangerous course of permitting the government to decide what its citizens may say and hear. Do you agree with U.S. District Court Judge Bernard Decker's upholding the First Amendment rights of Nazis to march in Skokie, Illinois? Why or why not? What criteria has the U.S. Supreme Court used to limit freedom of expression? Bless you. What, if any, benefit is there from the presentation of ideas that are designed to alarm, antagonize, and offend members of society? Should the fighting words doctrine of Chaplinsky versus New Hampshire be reinvigorated or revived and applied on a broader scale to deny First Amendment protection to volatile or explosive speech like that expressed in places like Charlottesville, Virginia in August of 2017? Why or why not? You may begin.
United States District Court Judge Bernard Decker allowed Nazis to declare their First Amendment rights in Skokie. Skokie is a suburb in Chicago, Illinois, where many Holocaust survivors live. 40 years ago, Nazis marched through Skokie to have their opinion heard. The Nazis were white supremacists and were asserting their First Amendment rights, predominantly their freedom of expression. Skokie was the center for American neo-Nazis to gather. George Van Dusen, the mayor of Skokie, provided the information that Skokie has the second largest amount of Holocaust survivors in the world next to Israel.
The United States Supreme Court has set the criteria for limiting freedom of expression clearly. If someone is damaging another person or their belongings, the freedom of expression can be limited. A court case that fully describes this is Virginia v. Black, 2003. Here, Barry Blackburn crosses into Virginia statues in a way of expressing his opinion. However, this expression of opinion destroyed the statue. The court decided 7-2 in favor of Virginia, and Barry Black has freedom of expression limited, as what he did was destructive and detrimental. However, in some cases, freedom of expression cannot be limited, but the citizen still sees the effects of his or her decision. A prime example of this is the Nazis' march in Skokie, Illinois. The Nazis were not harming anyone or anything, therefore the group could not be prosecuted. The United States Supreme Court has set the criteria that freedom of expression can be limited if the act is harming anyone or anything.
40,500 of Skokie's 70,000 residents are Jewish. Frank Collin, an American neo-Nazi, used his First Amendment rights to peaceful assembly and marched through Skokie to have his opinion heard. No violence occurred, and therefore what happened was entirely lawful. It is a good decision to allow hate-mongers to expend their venom and rhetoric, to quote Judge Decker. If the government took too much responsibility in this decision, it could result in even more problems. Letting the people sort it out would emphasize the freedom they are expressing, and any adversity that occurred would serve as punishment to the potential violence. Therefore, fear is, in a way, protecting citizens' rights by serving as a threat of disorder to an event if it were to go wrong.
The fighting words doctrine of Chaplinsky versus New Hampshire in 1942 should be reinvigorated, especially in events like the riot that has happened in Charlottesville, Virginia in August of 2017, because it specifies the types of speech or actions which should be unprotected by the First Amendment. To exemplify, if an event happens similar to the one in Charlottesville or Chaplinsky versus New Hampshire, the fighting words doctrine could be used against the perpetrators of the event, because in those types of situations where there's an abundance of verbal offense and fighting words, people will be insulted and offended on a personal level. The purpose of the doctrine is ultimately to protect those who have been offended, insulted, and socially harmed. Furthermore, the fighting words doctrine could also be used in events similar to NSPA versus Skokie in 1977, because the National Socialist Party of America demonstration was likely against African American people, which under today's standards is deemed an obscenity and therefore falls under the fighting words doctrine. The fighting words doctrine should be revived because it further specifies limitations on the First Amendment and protects potential victims of those harmfully expressing their immoral opinions.
In conclusion, the U.S. District Court was correct in upholding the First Amendment rights of Nazis to march in Skokie, Illinois, because they are not being destructive. Furthermore, a structure has been set into place to help the judicial branch in making decisions. This structure being one cannot be punished unless they are damaging a person or object. which leads to the point having a little fear instilled into the citizens can be a positive thing for the government and society. To finish, the Fighting Words Doctrine protects people who have been insulted in mental and social situations. The doctrine shall be revived for the reason it protects even more people under the First Amendment.
Thank you. You mentioned obscenity as falling under the Fighting Words Doctrine. I'm not sure I got the connection. Could you explain that?
The literal words of the Fighting Words Doctrine included many descriptions or adjectives for actions, one of them being obscenity, and other ones include maybe like lewd and profane, just literal words of the Fighting Words Doctrine.
Okay, so those are the terms in the Fighting Words Doctrine. How would that be applied? Could you describe that?
Well, that could be applied because the obscenity is describing the way that they felt in the doctrine, so it would help us understand what they were trying to say.
So were they trying to say that all obscenity would not be protected? Is that how that is used?
If it is offending anybody on a personal or legal level, then it is unconstitutional. Anything that falls under the doctrine that is considered hate speech or fighting words is illegal.
I think what my partner was trying to say, I don't think it's unconstitutional, it just falls under the Fighting Words Doctrine.
So, help me to understand, let me clarify some points. So it seems like you believe that the decision in the Skokie, the Collins case was correct. That the Nazis should have a right to march in Skokie.
Yes.
Okay. But then you believe that the Fighting Words Doctrine would help us prevent things like Charlottesville from happening. Yes?
Yes.
So therefore you're saying you don't think Charlottesville should occur. That was a situation that our laws should stop from happening.
Yes.
So help me differentiate that, right? Because the members of the rowdier part of Charlottesville were saying things like Jews will not replace us and blood and soil, and they're chanting this out holding these tiki torches. Why is that different than the Nazis marching down the street in Skokie, Illinois with swastikas?
Because in Skokie, Illinois, no violence occurred, no physical violence occurred, and no individual was harmed. So it wasn't, they weren't harming anyone. The neo-Nazis weren't harming anyone or their belongings.
Does psychological harm count though? Like if you're a Holocaust survivor, you witnessed 6.5 million Jews being exterminated by people wearing swastikas, and now you have someone marching in the street holding up an eagle and swastika. Are you psychologically harmed by that?
In theory, that could happen, but there's no evidence of that happening.
If a group wanted to march down a New York street with a flag of ISIS and claim that it's only just a beginning, would you be prepared to have that happen? Do you think they should be protected and allowed to do that?
Well, according to the First Amendment, they do have a right to assembly and speech to say whatever they want, or almost whatever they want.
So you'd be comfortable with that happening? I'm sorry, comfortable, no. You would think that should happen?
Legally, they're allowed to do it, but morally, probably not.
Well, if they're instilling fear into the citizens, that could be considered they could be limited, their speech, their First Amendment right of freedom of speech could be limited because, for example, if you go into a movie theater and there's not really a fire, you can't go in and scream that there's a fire. And that would be almost the same thing, except the ISIS situation is 10 times worse.
I mean, obviously, I'm trying to draw a 21st century parallel to the Nazis going through Skokie. That you had a community that was overwhelmingly sensitive to the Nazi presence. New York City would be incredibly sensitive to an ISIS presence saying it's only a beginning. I mean, that's clearly gonna incite people, which is exactly what happened. And the Supreme Court said, but they have the right to express their opinion. You believe, given where the court is, that march should be allowed to occur?
Which march are you referring to?
The one with ISIS.
Again, legally, yes, because they're just expressing their First Amendment rights. But from a moral standpoint, no, because they're instilling fear in the citizens.
Okay, thank you.
All right, well, let's transfer into the schools now. We've gotten out of the streets and now we're in the school building. What about your First Amendment rights in school? Do these same restrictions and permissiveness apply?
There are more restrictions to our rights when we are in school. For example, with social media, for example, or with bringing certain objects into the school, we don't have as many rights in school as we do outside of school for the safety of people around us.
So the Constitution doesn't apply to you?
No, it does. It's just, for example, we can't, because people have the right to a public education, and if we do something to disturb the right of public education, then we're being unconstitutional.
An example of this could be Tinkers vs. Des Moines, where the students came in with the armbands on their wrist. I believe they were not allowed to have those armbands, and they were not allowed to return to school until they agreed to have the armbands go away. So the Constitution still does apply to us, but it's a little bit more sensitive, I would say.
And you agree with that?
Yes.
Perfect the way it is.
Well, so you're saying it's that the way it applies is a little bit different. Can you, so the differentiation is if you disturb someone else's education, isn't part of education expressing beliefs? I guess that's it.
Yeah. Wow, do you feel better now?
Yes.
Oh, yes, we've got one down. And how hard it is to be the first group to start in front of your class, in front of these strangers up here. How great you did. You should be very proud of yourselves. I like the way that you all interacted with one another, and we're making sure that each of you got an opportunity to speak. I like the way that you're struggling with this very difficult concept of free speech and applying it in real world, in your school, and in your communities. It's a difficult balance between our freedom to speak our mind, whether people like it or not, versus protecting people, places, things from destruction or harm. And we can see your struggle. And that's true. It's true today, it's true for us, it's true for all. And so I really appreciated that. And when we got to the school, I like that you recalled the Tinker case and applied it in an appropriate manner, because that is the case that explains that theory. So I appreciated all of your remarks.
Definitely echo my colleague's sentiments. It's a hard task to go first, and even more so with this question. Right? This is a really, really big question. And there's a lot of stuff to pack in. And I thought you did a nice job of editing down your opening statement, really honing in on what's important. I especially like that you really drew our attention to how extreme the example of Skokie was, right? Showing us that the mayor talked about the second largest survivor population being in Skokie, Illinois, a city second only to a whole country being Israel, right? That's a really, interesting distinction to make. And even in that place, the right for the Nazis to march down the street was upheld. There's a little bit of contradictory nature to some of the opinions you guys are holding, right? Because you want to draw a bright line, and the unfortunate part is, our core precedent is not bright line, right? Even adults struggle with, trying to reconcile these cases that all have very different outcomes. So just spend a little more time maybe thinking about what are the implications of some of the choices you make, right? By saying, right, there's no evidence that psychological harm occurred to the Nazis. But then a little bit later, you're talking about, well, if we're instilling fear, then that should not be protected constitutionally. If you're a Holocaust survivor and there's a Nazi marching down your street, the fear is real, right? We don't need a psychological study to tell us that fear is real. So, spend some time thinking about, okay, if we take this position, right, if we say this is the rule, then what does that do? I think when you do that, it's going to open up some more possibilities for you on how to talk about things and try to build this coherent picture of free speech. That's an incredibly complex task. It's something that our generation is struggling with now. I can't wait to hand the ball over to your generation. I think from what we saw today, you're going to do a much better job at figuring this stuff out and coming up with good answers than our generation has before you. So I'm very proud and excited about the future.
I was actually quite happy that my colleague asked you about the question of fear and psychological impact, because I got a little concerned when I heard that the Nazis weren't causing any harm to anyone or anything. I got a little worried about that, which is what prompted me to give you what I thought would be a very difficult question. ISIS and walking down New York City streets, where clearly memories are very clear of losing thousands of people. You know, it's one thing for a part of our population to remember something that happened in Europe. It's another thing for a whole country that felt it got gut punched with 9/11. So I really was glad that you took the time to say, I don't want this to be the answer. Morally, it is wrong, but I have to be consistent. And I was pleased that you worked it out that way, and I understood that you were struggling, because hopefully that is a struggle. She's kind of telling me I'm talking. Very good.
Thank you.